my project, I will be talking about legal strategies for transgender rights cases. However, before I begin, I want to lay out some definitions that will be helpful in fully comprehending the information and the arguments that I will be presenting. The first term is sex, which refers to biological sex. That is, one's classification as a male, female, or intersex individual by indicators such as sex chromosomes, internal reproductive organs, genitalia, etc. Sexual orientation, the next term, is completely separate from biological sex. It refers to one's sexual and/or romantic attraction to others. Sexual orientation is often classified as homosexual, heterosexual, or bisexual. However, other sexual orientations are now often recognized and encompassed within the LGBTQ+ umbrella. Gender, the next term, is a cultural construction of certain behaviors, actions, attitudes, etc., that a culture often relates to biological sex. These behaviors often fit into certain gender expectations. For example, women are expected to be more docile, petite, fragile, etc., and men are expected to be more strong-willed, in charge, and ambitious. Gender is performed externally. The next term is gender identity, which differs from gender because it's internal rather than external. Gender identity refers to the gender with which an individual identifies, but may or may not be presenting externally and biologically. Transgender refers to an individual whose gender identity does not line up with his biological sex or her biological sex. For example, someone who was born with male genitalia but identifies as female is a transgender woman, and vice versa. Sometimes being transgender is as simple as performing the gender with which one identifies, such as a transgender woman who does not use hormones or go through sex reassignment operations but still presents herself outwardly as a woman through clothing, hair, makeup, and other things like that. However, some do choose to undergo hormone treatments and/or operations, but this option is not financially accessible for everyone. We see it all over the news. Transgender people across the country are fighting for the same rights others already have. Whether it be equal pay, wrongful termination, or other forms of discrimination, transgender people want to be heard, and they want to correct the injustices that they and their predecessors have been facing for decades. Most recently, late last year in 2019, the transgender rights movement took its biggest step yet, with the United States Supreme Court's decision to hear its first case dealing with transgender rights. The Equal Employment Opportunity Commission, also known as the EEOC, and Amy Stevens versus R.G. and G.R. Harris Funeral Homes Incorporated. Amy Stevens was an employee for the funeral home in Michigan from 2007 to 2013. At the start of her employment, Stevens was male and used the name Anthony. However, in July of 2013, Stevens told her employer about her history with gender identity struggles and that she would be transitioning to a woman and will undergo sex reassignment surgery. Shortly after that conversation, Amy Stevens was fired, leading her to file sex discrimination charges with the EEOC. The trial has not yet been deliberated by the Supreme Court, so I will be using legal theory to predict the outcome of the case. Prior to 1990, attorneys representing transgender clients used the approach of framing their client as mentally ill or disabled. However, due to some legal changes that came with the Americans with Disabilities Act of 1990, successful attorneys have shifted to arguing that Title VII of the Civil Rights Act of 1964, although not explicitly stated, includes protection over transgender people. Before 1990, many legal victories for lawyers representing transgender clients came by relying on the medicalization of their transsexuality, framing their client as mentally ill. Transgender people were even able to get public funding for their sex reassignment surgery due to attorneys' utilization of, quote, expert witness testimony that the surgery is medically necessary as a cure for illness, end quote. The transgender petitioners would, quote, characterize themselves as people in need of a clear surgical gender assignment, making it impossible for advocates to question our society's strict system of gender classification system and serve their clients' needs at the same time, end quote. So, rather than utilize strategies aligning with the current state of trans activism, attorneys used a method of retaining gender norms, framing their client as ill and in need of switching from one accepted gender role to another. In the 1978 case, B v. Lackner, the transsexual plaintiff won a case earning funding from Medi-Cal, the medical welfare system in California, to fund her sex reassignment surgery. Originally, Medi-Cal refused, claiming the surgery was cosmetic and unnecessary. However, the court ruled that gender reassignment operations cannot be considered cosmetic based off of expert medical testimony. The court ruled the surgery necessary to amend the plaintiff's, quote, gender identity dysphoria, which has since been renamed a few times in the DSM. This strategy was problematic not only because medical experts may not always agree with the idea of sex reassignment surgery, but also because it belittles the transgender person into someone who is ill and needs to be fixed rather than an individual who is finding their own identity out of their own volition. Nevertheless, despite its issues, the American Psychological Association's Diagnostic and Statistical Manual 5, which is the current DSM model used, still lists what is now named gender dysphoria as a mental illness. Albeit this strategy became less popular after the Americans with Disabilities Act of 1990 was passed, in which Congress specifically left out transsexual people so that the rulings based on illness could no longer be used to provide state funding for gender reassignment surgeries. Another popular strategy used in the past, which is still used today, is claiming that Title VII of the Civil Rights Act of 1964, which bars discrimination based on sex, applies to transgender people, despite the lack of explicit verbiage. However, the success of this strategy surrounds the 1989 case Price Waterhouse v. Hopkins, which served as a turning point for transgender people and their success in the courtroom. Prior to that Supreme Court case, transgender cases attempting to utilize Title VII often failed. One such case is Elaine v. Eastern Airlines. In the 1983 case, Karen Elaine, a pilot for Eastern Airlines, was fired, and she sued for wrongful termination based on sex discrimination. In the 1970s and early 1980s, the court had a traditional view in sex and gender, and they were determined that sex and gender were two distinct categories. Thus, Title VII only protected sex discrimination, not gender discrimination. This interpretation meant that it was against the law to discriminate against a woman because of her being a woman, but not because of the way she dresses or acts. The court also emphasized the fact that Title VII failed to mention anything about a sex change or a sexual orientation, so discrimination based on that phenomenon did not apply, and LGBTQ people were not protected under Title VII. Any change in meaning was said to necessitate a decision from Congress. Therefore, the court ruled that Elaine was not under protection of Title VII. However, this, quote, logic has been undermined by the court's growing recognition that the ills contemplated by a statute's drafters should not serve to limit the application of those laws, end quote. And we see examples of that in more recent court rulings. As mentioned previously, Price Waterhouse v. Hopkins was a landmark decision that completely altered the way cases filing against sex discrimination would follow, and its strategy has become known as the Price Waterhouse theory. The case was born when Ann Hopkins, a cisgender woman, sued her employer because they tabled her candidacy for a year and then refused to consider her again. Her employer did so on the grounds that she was a manly woman, and they used words such as macho and masculine to describe her. Some of Hopkins' colleagues suggested that she tried to act more like a lady or more femininely in order to earn more acceptance in the workplace. The case went to the Supreme Court, which reaffirmed the decisions of the lower courts, deciding that Hopkins' claim of being sex stereotyped was banned under Title VII's ban on discrimination based on sex because gender cannot be a relevant aspect of the employment decision. If gender performance is at all brought up or used as a basis of discrimination, the employer has acted on gender stereotypes and is in violation of Title VII. The case has been applied by other courts to LGBT individuals because discrimination based on sexual identity falls under discrimination based on nonconformity to gender stereotypes. Thus, it has been applied to transgender cases since its decision. In the case Schwenk v. Hartford, the court stated that sex and gender have become interchangeable due to the Price Waterhouse decision relating sex stereotyping to gender performance stereotypes. Additionally, in the case Smith v. the City of Salem, the court ruled in favor of a sex discrimination claim against a transgender woman firefighter. The firefighter had worked as a male for 7 years with the fire department and had been diagnosed with gender identity disorder prior to announcing to her supervisor that she would be transitioning to a woman. Smith was found to be not masculine enough and was fired shortly after. The court found that due to Price Waterhouse, the Supreme Court had constituted that Title VII includes biological sex and gender discrimination. So, discriminating against Smith was the same as discrimination against Ann Hopkins. However, the Price Waterhouse case's decision does not mean that all cases dealing with discrimination against transgender people are automatically solved. The 2000 case, Broadus v. State Farm Insurance, a sex discrimination suit against State Farm, the plaintiff, Broadus, a transgender man, was not victorious. Broadus's attorney wrote a complaint of sex discrimination that implied Broadus's boss's behavior was due to his personal belief that a woman should not look like a man. However, in his deposition, Broadus framed the discrimination as against his being transgender and his sexual orientation, rather than his failure to properly fit the male gender role. The court dismissed the case. Clearly, transgender protection under Title VII is limited to only very specific instances as, quote, sex stereotyping is actionable, or as discussed at an employee sex change, end quote, transgender identity or sexual orientation is not. It seems attorneys and their clients are going to have to be careful that their case fits within the Price Waterhouse framework in order to be successful. Although Title VII has become a relatively reliable tool in discrimination cases, it is case-specific. So, what does that mean for Amy Stevens? Revisiting her case, Stevens joined forces with the EEOC to file a discrimination suit against Harris Funeral Homes Incorporated, claiming the funeral home had violated Title VII of the Civil Rights Act of 1964. The EEOC filed the case in September of 2014. Stevens had been hired in October of 2007, meaning she had worked for the funeral home for about 6 to 7 years. The EEOC claimed that Stevens was fired because she is transgender and/or because of her gender transition and or because she refused to conform to the funeral home's gender expectations, specifically in regard to the dress code. The EEOC claimed that the funeral home was operating unlawfully in regard to their employees because the establishment only provided uniforms for the male employees and not for the female employees. The EEOC motioned to invoke Price v. Waterhouse's theory of sex discrimination, albeit the court denied the EEOC's motion, ruling in favor of the funeral home. The funeral home's owner did admit to firing Stevens because she was going to dress like a woman. However, the funeral home utilized two main defenses. The first is that the establishment already has a specific dress code in place, requiring men to wear suits and women to wear skirt suits. The second is that the business is exempt from Title VII under the Religious Freedom Restoration Act. The funeral home argued that upholding Title VII would impede their ability to conduct business in compliance with their religious beliefs and values, which they argue is directly related to the strict dress code set in place. The EEOC then appealed the case, and it was heard by the Sixth Circuit. The Federal Appellate Court ruled in favor of Stevens, holding that the EEOC holds the right to judge Harris Funeral Homes for its unlawful termination charge due to the funeral home's violation of Title VII of the Civil Rights Act of 1964 for firing Stevens because of her transgender identity and her unwillingness to conform to the funeral home's gender-specific dress code. It ruled that discrimination against a transgender individual is prohibited under Title VII of the Civil Rights Act of 1964, claiming that it is impossible to disassociate discrimination against a transgender person and against a gender nonconformity. The court also found that the funeral home was not exempt under the Religious Freedom Restoration Act. Clearly, despite certain landmark cases, the court still cannot agree, and given the current political climate, it is not clear what the Supreme Court will decide in the Stevens case. The EEOC is invoking Price Waterhouse, which, as we know, has been victorious in the past for the cases discussed earlier, including Schwenk v. Hartford and Smith v. the City of Salem. Nevertheless, these cases fit the mold of Price Waterhouse theory perfectly, which is not the case for everyone. As we saw in Broadus v. State Farm Insurance, for certain courts, just being discriminated against for being transgender is not enough, and in order to apply Price Waterhouse and Title VII, the discrimination has to be specific. However, with the EEOC's emphasis on Stevens' termination as partly due to her non-concordance with the gender-specific dress code, they have solid grounds for arguing that Harris Funeral Homes fired Stevens because she would not conform to the funeral home's gender expectations of how a man should dress. Additionally, with Stevens' 7 years of employment, it's safe to assume she was a good employee and was only fired because of her gender performance shifting from male to female. Furthermore, Harris Funeral Homes admits to firing Stevens because she was going to begin presenting as a woman. I argue that the decision could go either way depending on the court's interpretation of the Religious Freedom Restoration Act versus Title VII. And given the current administration and President Trump's having the most recent Supreme Court appointment, the odds do not look great. The Supreme Court's decision, regardless of what it may be, will make a deep mark in history for transgender people, and has the power to either set them back immensely or propel them forward into their movement to end gender stereotypes and create social change.